Asanteni sana.
Yes, thank you very much. Welcome, and make yourself comfortable.
Thank you.
You have been here not long ago.
Yes, my lady.
Yes, so
Thank
we'll still do a round of introduction for the sake of the record.
Yes,
my name is Martha Kome. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you, my lady.
Good morning.
Good morning.
Name's Isaac Ruto, also Vice Chair.
Thank you.
Good afternoon, my Lord. Jacqueline Ngutia, Commissioner, welcome.
Good morning and thank you.
Good afternoon, Justice Katwa. My name is Caroline Lani. You're welcome.
Thank you and good afternoon too.
Good afternoon, Judge. My name is Charity Kisotu, a Commissioner. You are welcome.
Thank you very much.
Good afternoon, Judge. Omwanza Mbati, karibu.
Thank you and good afternoon.
Good afternoon. I'm Joaquin Dongo, representative of the Supreme Court on the Commission.
Thank you.
Good afternoon, Judge.
Good afternoon, my
Anthony Mrima. Welcome and I wish you the best.
Thank you very much.
Good afternoon, Justice Kigen.
Good afternoon.
Fatuma Sichale, I'm your representative at the Commission. Karibu sana.
Thank you very much.
Good afternoon, Judge.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you.
Good afternoon, Judge. Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Thank you very much, Commissioners. Judge Joseph Kipchumba Kigen Katwa.
Yes, my lady.
Could you tell us your county and your ethnicity?
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. Do you know why we ask that intrusive question?
I do, my lady.
Why?
I think for regional balancing and, basically regional balancing, I think.
Is it a constitutional imperative?
Yes.
Which particular article?
I can't quite place my finger on the exact article, but I would say it is intended by Article 10, Article 7283, and Article 236.
Yes, very well. So now we will start. You were here not long ago, and I think the challenges I have is what questions to ask you, because we recently interviewed you successfully for the judge of the Court of Appeal, and you have hardly been there for 3 months. You under normal human HR practice, human resource practice, at least one stays in a job for 6 months to be evaluated for promotion. You haven't been there for even 6 months for promotion. So maybe you can explain this before we go to the questions.
Yes, my lady. I know that you very particularly mentioned the point that I haven't been there for more than 3 months, and that in an ideal environment, I should have waited for a little more time so that there is perimeters for my evaluation for promotion. My lady and commissioners, my understanding of why I am here is different from that. My understanding is that I've come here for evaluation as to whether or not I'm eligible for appointment to the Supreme Court. And that eligibility is not a question of promotion, it's a question of whether I'm qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Mm-hmm. Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you.
Mm-hmm.
Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court, and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment of want. I went to Kiplombe Primary School. I went to Mother of Apostles Seminary. I then went to St. Patrick's High School, then came to Nairobi University. And through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years. And I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums. And the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I'll not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. and the legal regime. I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Ishale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans
yes,
as regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as a Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who apply to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petition. The other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important, it's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law. And I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history?" I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be, yes, how did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail? Keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract, that you have to have a relationship with the person you are suing. But then the consequence of that case was that if you are offering a product, it should be probably in more developed law now, consumer rights. If your items cause damage or injury to somebody else, the fact of lack of privity of contract is not a defense to your liability for what you're offering to third parties.
So that is a law after 1928, but before 1928, you had to establish that there was privity of contract. Now, coming back home to the Supreme Court, what are some of the notable jurisprudential decisions that you can say have impacted our lives?
How many, my lady?
Pardon?
How many?
Give me 4.
Okay. So I think the most remarkable ones for me are 2. The first one is BBI. And the issues then were whether, in the name of amendment, the executive could torpedo the Constitution, or could replace the Constitution in the name of amendment. And I thought judiciary came out very proudly there to firmly put down their foot and say, we can only change the Constitution using what is there. And I thought that was a very momentous
So
time.
that is one.
Yes,
one.
2.
Yes.
Is the 2017 elections, August 2017 elections, where the judiciary distinguished itself in refusing to recognize the presidential elections. I did not and do not agree with the reasoning of the court then, but I thought even then we shouldn't miss the point of the independence of the judiciary in making that decision. I thought it was a very momentous and strong statement of the independence of judiciary.
I agree with you.
Yes.
Number 3.
The third one from the Supreme Court would be the finance bill. For quite some time, I know there has been pull and push between the executive and judiciary, and it entails questions of whether the judiciary is being activist, is overreaching, and is micromanaging the executive. The concept developed in that finance bill, suspension of declaration of invalidity, is a very important measure, because then it gives the executive time to adjust itself to the requirements of the circumstances of the situation.
All right. And finally, the fourth one?
The fourth one is the Muruwatetu one. Of course, it is very controversial, but then the determination that there has to be a distinction between the roles of the executive and the judiciary and the executive, the separation of powers was to me a very important.
Was that in Muruwatetu 1 or Muruwatetu 2?
In actually both, because in one, the decision I thought was a general statement that the judiciary should not seem to determine the sentence.
All right.
Should not tie it. But then in the Muruwatetu 2, then the Supreme Court came back and said our intention was only limited to murder.
All right.
I think, yeah.
So it is like the issue of discretion, mandatory sentences.
Yes.
The executive should not interfere, but it should be left to the judiciary. Yes. Thank you. That's all, Honorable Chief Justice.
Thank you, Commissioner Mwansa.
Thank you, CJ. Good afternoon, Judge, again.
Good afternoon, Commissioner.
Judge, Article 19 of the Constitution is the article that starts with the rights and fundamental freedoms.
I'm allowed to refer?
Yes. Okay. And now, Article 19.3 provides that the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. Then Article 19.3b provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with the chapter. And 3 provides that those rights are subject only to the limitations contemplated by the Constitution. Now, in developing that issue, we have what we call enumerated and unenumerated rights. And it could seem that what Article 19.3b states or provides for are what we would refer to as unenumerated rights. Now, while enumerated rights are clearly written, the unenumerated ones are inferred. So that the concept is that there is a limited list of rights in a constitution that does not mean that fundamental rights do not exist. So the first question is as follows. Are there rights that you would say that are fundamental and are not contained in Chapter 4 of the Bill of Rights, but they are unenumerated and you can infer them? And if so, if you probably can list maybe 4 or 5.
Okay. Commissioner, I'm not sure I know I have an answer to the point you made about the enumeration. I'm not aware whether there is anywhere where they are listed, other than in the Constitution, of course, which I'm aware of. But I don't know whether there is somewhere else tabulated. Commissioners, I will pray to probably refer to the experiences I have. Some of the rights that I know are internationally recognized but are not captured in the Constitution is, for instance, against genocide. I am fairly sure it is not in the Constitution in the word genocide. I know there are issues of human dignity, human rights, against servitude and all that. But I think genocide as a crime is not there. And I'm borrowing from the International Criminal, the ICC statute. And I'm referring to the ICC Act because Kenya is a signatory which in effect then, and most of the world countries are signatories, which then means it is a recognized right. So genocide, war crimes, acts of aggression. Others that come to my mind, and they do not necessarily even relate to Kenya, is apartheid. I think there is generally condemnation of conduct that amounts to apartheid, and I think that could be one of the rights that you could incorporate there. The upheavals in West Africa resulted also in warrants and summons on issues of damage to World Heritage Sites. And so I think UNESCO protected locations, or rather damage to World Heritage locations are also a crime. Commissioner, I hope I've managed to make 5. I'm not sure if I have.
Okay. Now I want to go to Article 45, just to explore that topic.
Yes. So
Article 45 of the Constitution provides that the family is the natural and fundamental unit of the society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45(2) provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal benefit of the law. And then there is another important article. 27(4) provides that the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, belief, culture, dress, or language. Now, this article, in the first draft of the Constitution, actually provided for discrimination against sexual orientation. But subsequently, in the discussions that followed and the final draft, excluded that reference. Now, if again you read Article 2(6) of the Constitution, it provides that any treaty or convention ratified by Kenya shall form part of Kenyan law under this Constitution. So I wanted to ask a question using that context. Now, Article 16 of CEDAW, the Convention Against Discrimination of Women, provides that a woman has a right to choose their partner. And the definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I've given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights. Yes. And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.3b, that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 3, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes. So I tried to set the context because sometimes there had questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question, is D, subjected to torture in any manner, whether physical or psychological. So, physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have, and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological? Because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m., the flag is about to be lowered, stand up and be at attention. Or, do the loyalty pledge.
Okay, so can I answer?
Yes.
Yes, my answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where values exist. It wouldn't seem to me like anything is being extorted out of the children. They're not being asked to make any confession. They're not being asked to sign off any rights. They're not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judicial authority. And one of the guiding principles under 3 is that the court should develop rich jurisprudence that respects Kenyan history traditions and facilitates its socio-economic and political growth. Are you aware of instances whereby either the Supreme Court has developed the common law or it has infused these constitutional principles and created sort of a Kenyan context interpretation of the law? And I get this from what Justice Mutunga used to say, that we should develop jurisprudence that is indigenous.
Okay, so I will answer the question in terms of what indigenous jurisprudence and principles of law have been developed by Kenya, and with reference to your question, particularly by the Supreme Court. I think in the recent past, the Supreme Court has made a determination on the question of matrimonial property. And in it, I think it is an indigenous contention that contribution for purposes of the rights of a spouse can be gauged, not limitedly to financial contribution. It could very well be in kind, family upkeep, taking care of the children. And I think that's an indigenous contention, that contribution is not limited to financial contribution. I think that one. The other one, although I can't say for us absolutely that it has been determined by the Supreme Court, I think is the issue of trust on land. Being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial property. That where you have one spouse's name being registered in a property, that property is being held in trust for both family members. I think that is an indigenous contention. I know there's this other point that, unlike other jurisdictions, Kenya allows registration of marriages based on either civil law, customary law, or personal law. The accommodation to register marriages is not a familiar jurisprudence in other countries, and I think it's also an indigenous development. Commissioner, that's how far I can think immediately on my feet. I know I haven't answered your question in cross-reference to Supreme Court limitedly, but I think in the course of answering it, I have referred to some of the ones developed by the Supreme Court.
All right, thank you. Thank you, CJ, that's all.
Thank you.
Thank you very much. We now move on to the Honorable Attorney General.
Good afternoon, Judge, again.
Good afternoon, AG.
Now, we have instances where the Court of Appeal declines to certify a matter, and the intended appellant or petitioner to the Supreme Court applies for leave on the grounds that the petition of appeal raises issues of general public importance.
Yes.
You could agree with me or not, but the Supreme Court's jurisprudence has not been consistent in settling the question of what constitutes a matter of general public importance. Do you think there is a need for jurisprudential coherence in determining what constitutes constitutes general public importance. For example, or for instance, there is a pervasive understanding of what constitutes public interest. And rarely do courts differ on what constitutes public interest. But we cannot say the same of general public importance. So as you answer, you may kindly also tell us whether there is a difference between public interest and general public importance, and whether or not there is a need for jurisprudential coherence and guidance on the same.
As usual, AG asking me the toughest question. So let me start first of all by saying, I would have thought the Supreme Court, because it has reiterated this, I know every other person wants a chance at the Supreme Court, and so there have been so many applications to the Supreme Court. And I think the Supreme Court has been very consistent in saying that for general public importance, the criteria is number one, that the issue you are seeking the court's attention for should transcend your personal dispute and should be a novel issue that needs resolution and will be used by other parties. And thirdly, that it should have escalated from the courts below to the point of the Supreme Court for determination, that you do not jump onto the Supreme Court and ask them for a determination when it has not graduated and escalated through the courts below. Now, you are then, I also wondered whether your question was also whether the court has settled jurisprudence on whether they can consider interlocutory applications. And my reading of it is that initially the Supreme Court had said we will not deal with any interlocutory application. We will only determine when it has yielded a judgment. But then with time, they have put some riders where they have allowed interlocutory applications, even when the substantive hearing has not been determined. Now, on the specific question of public interest and public importance, that was the question, Honorable AG. Public interest and public importance.
Whether there is a difference in definition or understanding.
I would contend that public interest and public importance is one and the same thing, especially for purposes of the determination of the question for the Supreme Court of a matter of general public importance, because it would be both in the interest of the public and of importance to the public. Whichever question they have to wrestle with would be one that has been distilled as being one that the public is interested in and is very important for the public. I know the concurrent argument between the competition between public interest and I think national interest, but that's not your question. But I would say, in answer to your question directly, for purposes of Supreme Court's jurisdiction on a matter of general public importance, I think I would deem and consider any matter that is of public interest and public importance to be one and the same for purposes of the court's consideration. And I would say the court has obligation to consider them, whether it amounts to being a matter of public interest or it amounts to a matter of public importance.
Okay, and finally,
yes.
Do you think there are instances or cases where the Supreme Court has made a mistake? And if so, would they have done anything better? If you can identify one or two. I'm not saying they have. I'm asking you whether you think there are cases where they have made a mistake, and if so, would they have done better?
Okay. It is an unfair question because I'm a candidate, but let me answer it all the same. Murwatetu 1, I think could have been done differently. Because Murwatetu 1 would seem to have just made a general proposition that the legislature should not spill into tying the hands of the judiciary, a judicial officer. And that in consequence then has caused the need to rush into clarifying. So Murwatetu 1 probably would have been done a little, would have been adjusted a little more. The second one is SGR. And I'm saying this from my own personal perspective. I could very well be wrong. I thought in the litigation between Okio Mutata and SGR, where Okio's argument was that we need to have access to the agreement between Kenya government and Chinese government to be looked at and to be evaluated and to be audited. When the Supreme Court said that we are declining and avoiding dealing with it because the way the exhibits, the documents upon which the case was being made was questionable, I thought it was sacrificing a small issue on a very big and important public point, being that it was more important to allow the audit of that agreement and not to have sacrificed it by reason of how the material used to make that decision was obtained. The other one, Honorable AG, is the issue of Martha Karua. The way I understood the case of Martha Karua was this, that she had challenged the elections, she had filed an election petition. And then the issues moved from the High Court to the Court of Appeal to the Supreme Court. By the time she was done with all that, 6 years had expired, and therefore her case got lost because of expiry of time. The East African Treaty provides for room for contention on human rights concerns. And my understanding of what Martha Karua had taken to the East African Court of Justice was to say that the totality of the way the court handled my matter, the totality of the way the law is structured, is such that I have been victimized, because I've been victimized by being placed in a situation where time has expired before I've indicated my right, and therefore my rights have been violated. I thought the Supreme Court, instead of dealing with that narrow question of whether or not the East African Court had determined the question of her violation, instead dealt with it as if the East African Court had evaluated the merits of the Kenyan courts. And I thought that was not what Martha Karua's case was. I thought Martha Karua's case was just limitedly saying the totality by reasons of actions and omissions in the statutes, in the Constitution, in the handling of the matter by the courts is such that my rights have been violated. And so should I be compensated? But instead, the decision that came out was, no, you cannot take us to East African Court of Justice to
Thank you. Maybe just a follow-up question on Murwatetu.
But may I say also, Honorable Attorney General, this is the second time you're asking me that question, because the last time you asked me whether the East African Court of Justice can decide on matters that belong to domestic jurisdiction. I answered it, and I think correctly, but then I didn't have this authority. I saw it much later, and I wished you could have answered me. I'm glad you gave me another chance to answer it more.
Okay, thank you. But a final question about Murwatetu 1.
Yes.
What is your view about the operations of a statute, retrospective operation of a statute that is declared unconstitutional? And I think that is one of the issues that should have been dealt with in Murwatetu 1. When a provision was declared to be unconstitutional, yes, or that the courts did not have discretion in murder cases, and therefore the issue of discretion was created. Now the challenge was it going to apply retrospectively? And from the understanding of the practitioners then, they started applying it retrospectively, and therefore the challenges in its application. Especially in criminal law.
So let me say, my understanding of retrospectivity of law is that a legal profession should not be allowed to operate retrospectively. However, there are instances when the law itself allows for that retrospectivity. And so, except where it has been directly addressed as having to operate retrospectively, I would contend that a law should not operate retrospectively. Now, in Murwatetu, I don't think the question was the retrospectivity of the law, because it was a question of a finding. It was just a saying, determine whether this thing is or black or green. And when the court then said, mandatory death sentence is wrong, is as constitutional impropriety, when it was made, when a finding was made to that effect, the consequences, the Supreme Court was not necessarily saying go and apply it retrospectively. It was just saying, the way I would understand is that nobody had brought this thing earlier, but now that it has been brought, we are making this finding today on the 28th of April. How then it will roll out is a question. It is. I don't think it is part of their mindset that we intend to have it to apply retrospectively. Of course, I appreciate that orders were made for reconsideration of sentences, but I think it doesn't quite fall on the four corners of the law of retrospectivity, because the law of retrospectivity refers to the enactment of a law. What the Supreme Court was doing was a question of making a finding on the face of the provision as to whether it was right or wrong. Regardless of the timing, whether so much time had passed or not.
Thank you.
Thank you.
Thank you very much, Honorable Attorney General. Now we move to Justice Murima.
Thank you so much, Honorable CJ and Judge. Once again, welcome. Let me take you back to the discussion on GPI under Article 163(4)(b), and a number of decisions from the Apex Court have settled the position that conflicting decisions can be considered as matters of general public importance, and upon certification, these matters can be rightly considered by the Supreme Court position, which I totally agree with. Now, the certification, if you look at Article 163(4)(b), is to be done by two courts, either the Court of Appeal or the Supreme Court. If it's done by the Court of Appeal, it can be reviewed by the Supreme Court. I believe this provision was made on the premise that these matters of general public importance will only emanate from the Court of Appeal, being the highest appellate court by that time, by the time the Constitution was coming into place. But over time, we have seen law coming up which makes High Court as the final appellate court, like the Small Claims Court Act. An appeal from a Small Claims Court, which is final in nature, is to the High Court. From there, you have no room to go to the Court of Appeal. And courts have decisively said you cannot assume jurisdiction, so there's no way you can go to the Court of Appeal. And as a result of that provision, we have seen so many conflicting decisions in the High Court from several issues of law raised before the Small Claims Court. The challenge now comes in that in as far as we know, the window for resolution of conflicting decisions is open before the Apex Court. There is the challenge as to whether we can leap from the High Court, so to say, to the Apex Court. Now, the question is, do you think, in consideration of public interest, the Supreme Court, for purposes of resolving conflicting decisions, maybe in the High Court or tribunals, which exercise final appellate jurisdiction, should take up these matters from the High Court straight to the Supreme Court and deal with them?
Thank you, my Lord. I think from my reading, the Supreme Court has clearly said you cannot leapfrog directly to the Supreme Court. So you really just have to go through the door of the Court of Appeal. Unless a statute, because I know there is the argument that some tribunals can go directly to Supreme Court. But in a normal litigation, then you can't enter the Supreme Court without passing through the Court of Appeal. I wasn't sure I got your question because you started by saying Small Claims Court, and I saw you almost said MCS also, because I think also MCS under the High Court. They can't go beyond there. And the question you're asking is where there are conflicting decisions, whether they should go to the Supreme Court. And just for clarification, very kindly, Commissioner, are you limiting your question to the conflicting decisions in small claims issues, or generally on issues that cannot escalate beyond High Court?
Let's be general.
Okay.
I brought in the issue of small claims as an example.
Okay.
But it's a general question.
Thank you very much. Yeah, of course, the other example would be the MCS. This is the way I would answer, my Lord, that I would think the Supreme Court would have jurisdiction if there is a genuine matter of general public importance in any of those issues, being a real identifiable issue that they need to resolve rather than a question of merits. And if it were to be the case, as you say, that there is concern that there is strangling of some causes not to go beyond High Court, I would see a petition being framed to cover, including the concern you have, that one, either the question arising from small claims courts is this, it is a matter of general public importance, or this issue in the MCS elections is of general public importance, and ask the High Court to determine whether they are substantive enough and to apply their minds. So there would be then a determination on two things. One is that it is so grave, it is of such a public importance that it warrants the consideration by the High Court. And if the High Court cannot, and if the court determines it and one of the parties is aggrieved, then leave as a matter of constitutional right to escalate it to the Court of Appeal and to Supreme Court. So that then for me, it's a question of how it is framed. It needs, all the issues just need to be placed on the table and they need to show gravity on the face of it. Because I would see if it is a question of small claims, it doesn't matter that it is it doesn't matter that it is a matter of small claims. It doesn't matter that the policy for small claims is finality of litigation. What matters is that if there emerges a very significant point that needs consideration by courts, and then I think it could still escalate, depending on how it is framed.
Now, Judge, if I get you right for clarity,
yes,
do I get it that you maintain that such an issue, even after you are satisfied that is an important question which needs consideration by the SCOC, you will give more credit to the process and maintain that you can only leapfrog from High Court to the Court of Appeal to the Supreme Court? Will you be looking at the process more than the substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer your question directly, my lord, that I insist you cannot leapfrog. And the reason why it is necessary not to leapfrog is because it needs consideration by the Supreme Court after the other courts have considered it. You can't fly it over to the Supreme Court before the other courts have considered and applied their minds and possibly resolved it.
Yes, so sorry for engaging you. I agree, yes, but this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said, if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. It's just a matter of taking it from the High Court to the Supreme Court and say, this is one of those you say.
Yes, my lord, but I think there are still some cures. For instance, if there are conflicting decisions, and that happened in the issue of statutory notices, they had to set up a special panel right from the High Court to the Court of Appeal before then it go to the Supreme Court. Okay, at that time there was no Supreme Court before it would go to the Court of Appeal. The issue of, the other one was the issue of arbitration. So that it is not good enough to just say, one High Court judge says this, the other High Court judge says this, so there's conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, 5 or 7 judges, either the High Court or the Court of Appeal, to give it a thought before it gets to the Supreme Court. I still insist, my lord, that even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of those minds probably will resolve the issue and harmonize it. And if there is no agreement, it can still escalate. But I would think it is right to say, just because there is a disagreement, you walk over directly to the Supreme Court.
Okay.
Even as a matter of fairness. I know the Supreme Court has said that, but even looking at it as a question of jurisprudence, it's better if it just escalates and all the minds have gradually considered it.
Okay, we can hold it at that. Yes. Though to me it may not be an issue of jurisprudence because it's an issue which is already settled. It's already clear that conflicting decisions are matters of general public importance, but we can hold it at that. Let's get to elections. We are some few months into general elections.
Yes, my lord.
And do you think, Judge, that there's a difference between general elections, fresh elections, and a runoff?
General election, fresh elections, and?
And a runoff.
Runoff.
Yes.
Okay, so runoff would be a situation where nobody garners 50+1 in a presidential election, in which case then the top 2 candidates would go into runoff. General elections is the standard cycle of 5 years elections, and fresh elections is where elections have been nullified and parties have to go back, or rather constituent entity, either a county or constituency, needs to go through another election.
That's very right, Judge. Now, I want us to consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election. And let's start from a point where a petition challenging a presidential election is filed in the Supreme Court. The position which has been taken by the Supreme Court is that in the event a fresh election is called or ordered, it is only the petitioner and the president-elect who should take part in that fresh election. We are together, so that end, Judge?
Yes.
Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, but with the leave of the Supreme Court, this candidate is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file pleadings.
Yes.
And in these candidates' pleadings, it's stated very, very clearly that I'm in total support of this petition. The election has to be nullified, and once nullified, I am interested to take part in the fresh election. So, the position of this candidate is clear, that I want to take part. He has not acquiesced his or her position in that he has stated very, very clearly in pleadings that if it is the petition succeeds, I also want to run. But the jurisprudence which has been developed as a term is that it is only the president-elect and the petitioner. And the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that its intention to run, and eventually the election is nullified and a fresh one called. Will this interested party be able to take part in that fresh election?
Thank you, my lord, for the question. We need to, okay, so your question, as is the nature of always illustrative scenarios, the question doesn't come out as to whether the petitioner is a candidate. But I want to,
the petitioner must be
and it is easier
candidate.
for me to answer the question if you don't, I don't have an answer to that question, because then we would then be looking at it and saying, what if the petitioner was not even a candidate, he's just a public interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as a person was a candidate in the elections leading to the nullification, they are eligible to participate, unless there is a specific reason why not.
Let me get to
Yes,
that, Judge.
Yes, sir.
You're saying in a fresh election,
yes,
all candidates are eligible to take part. If I get you right, that's your position.
It depends on the nature of...
No, I limited myself to the position taken by the Supreme Court, which is a case premised on the petitioner being a candidate.
Okay.
And the court said it is only the candidate who is the petitioner and the president-elect. But now I've introduced a further element of the interested party.
Yes.
And the reason why the Supreme Court says the other candidates should not participate is they have not taken any active step in expressing their desire to run in the fresh election.
Yeah.
But this is an interested party who has said, I'm interested. I filed my paper, I support this petition. And if it goes through and a fresh election is called, I'm interested to run. So they cannot be said to have exercised their position. They have stated clearly that I need to take part in the fresh.
My Lord, I would think that if an interested party has come and said, because an interested party, first of all, is one who has a stake and will be affected by the decision.
Yes.
If he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate, then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect. It would be just unreasonable. It would be awkward. So I would say if somebody has come and explained himself why he did not petition, what his stakes are, what he considers to be his rights, and considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression should be allowed to participate in the elections. And I'm comforted by the fact that the point you're making has not been quite directly dealt with, being the question of whether an interested party who comes and says, I want to participate, my explanation for not having filed the petition is this, these are my stakes. To the extent that it hasn't been addressed, and being an open question, I would say my view is that if he should be allowed to participate because he has come and represented his concerns, and if he can demonstrate his case, then he should be allowed to participate.
Thank you so much.
Thank you too, my Lord.
I believe that should be the position. Looking at the issue of access to justice, limiting costs, and many other parameters. Thank you for this rather long engagement. I wish you the best.
Thank you very much,
Thank you, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon.
It's been a long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit submissions that you have handled at the Supreme Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal, and also shared a no case to answer motion filed before the International Criminal Court. The exhibit excellent issue identification, coupled with strong ability to link facts to applicable legal principles. And looking at the ICC matter, where you submitted on the need for clarification on application of the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay. I know my colleague will ask you around that. So allow me to ask you 2 questions.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections, which Kenyans are usually keen on. Key strength in arbitration is finality, And that is why you find most laws on arbitration clearly provide for this fundamental principle. In the New to Aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration and the appellate jurisdiction of the superior courts in Kenya. So what the court held is that Section 35 of the Arbitration Act is silent on whether an appeal should lie to the Court of Appeal. And this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong arbitral award has stepped outside made a decision so grave, so manifestly wrong, and which has completely closed the door of justice to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of New 2, my recollection of reading it is that one of the issues the court had, so the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when I think it is Section 35 is silent. On whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter-arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how the Supreme Court arrived at its decision is to balance those 2 rights. One is the right to be heard and a right to challenge a situation where the decision of the High Court is so manifestly wrong on its face, vis-a-vis the desired intention of the 2 parties that there should be finality. And as a consequence of balancing those 2 interests, then the Supreme Court said that you will only appeal to the Court of Appeal where you're able to demonstrate that your situation is very distinct. It's not just the usual issues of disagreements or dissatisfaction or ordinary displeasure. You have to distinguish a very remarkable dissatisfaction with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why, to my mind, it requires leave, because that leave stage is where the court then will evaluate whether it is an ordinary displeasure or it has a very distinct legal or factual issue.
So according to it, does not in any way undermine the statutory design of that particular provision?
It doesn't undermine, and it prioritizes fair hearing and justice to all parties.
Okay, I'm satisfied with that response. And number two, the case of Mitubel Welfare Society versus Kenya Airports Authority. I know you know the facts, but what the court held is that structural interdicts are recognized reliefs in human rights litigation and Article 23(3), sub-Article 3 of the Constitution, particularly when it comes to enforcement of social economic rights such as housing. In this particular matter, the Court of First Instance had issued structural interdicts. The Court of Appeal overturned the decision, saying that structural interdicts were not part of Kenya. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year, there is the Omtata Tribunal's case. I think it was Omtata versus the National Assembly, where the court in the first instance had issued a structural interdict directing the National Assembly to come up with a tribunal's bill. And what the Supreme Court did is set aside that structural interdict that had been given against Parliament, and it held that, in part, structural remedies must remain exceptional, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards the Supreme Court has given for executive and legislature. So I would want to hear your views on whether we should maintain that the standard for judicial supervision on legislative processes should be higher than that of the executive supervision of executive compliance of court orders. And if so, what is your basis? What is your response, if it's yes or no, and give your explanation.
Thank you, Commissioner. So first of all, let me just answer the last limb of your question directly. Yes, I would think that there is sense in expecting structural interdicts to weigh more on the executive and to weigh less on the legislature. And the reason for that contention on my part is that the executive is assigned the function of executing either what the legislature has determined or what the judiciary has made a finding on. And so when it gets to the executive, it is more of executing it rather than evaluating, weighing, applying discretion. Theirs is really to do it rather than, it could entail a question of how to do, but not whether or not to do. And that's why in structural interdicts, then the executive would be told, please come back to us with your timetable of how you intend to implement what we have decided, how you intend to implement it. And then it is evaluated and then it is managed. So yes, I would say there is, thinking on my feet as you've asked me the question, I would see a legitimacy in requiring the executive more to comply with structural interdicts and to be more restrained in asking of it from the legislature. Now, going to the legislature, why I would say there would be need for more restraint in respect to the legislature is the legislature is a judgmental a structure like judiciary. They have their wisdom, they have their judgment, they have their discretion, they have their values. And they do that not at a personal level, but at a representative level. And so it cannot be right that a structural interdict is placed on them to say, pass a legislation that removes, and just for illustration purposes, that say remove members of parliament from CDF. All you can say is we declare a CDF with members of parliament in it unconstitutional and leave it to their judgment how best to take on board the observations of the court and to circumvent the concerns that have been issued. And so there is equality, there is a sense in which the legislature, I'm not saying the executive is any less, but the judiciary and the legislature are institutions which apply their minds, discretions, and judgments. And the judgment of the court in my view, it might not be appropriate for the court to attempt to use its mind and its value considerations and impose it on Parliament without giving them room to apply their wisdom. Because then it would violate separation of functions, it would amount to micromanaging the legislature. And probably just two more observations about it is to say that the general nature of how the courts deal with legislative output is to wait for it to be finalized. You don't go in and say, do your second reading today or take it to public participation today. You let them run the whole process. And when it comes to court is when you evaluate whether it was done properly or not, whether there was public participation, whether it went through all the stages and all that. And so structural interdict would have that inverse effect. It would have the inverse effect of seemingly micromanaging the legislature. And lastly, being a fairly later decision from the Supreme Court, I sometimes wonder whether the lessons from the case of over 30% gender representation in all government entities, including legislature, where the court had said you must immediately apply the 30% plus, and it has never been achieved up to today. Whether that was a lesson also to say, handle only what you can handle, and issue orders which you can actually execute, that you should not place yourself in a situation where you issue orders that you cannot, that you might not be able to implement. And the other one is the point made also somewhere in the Murwatetu cases, saying that the legislature has the right to decide what is criminal and what is the punishment. The court will only come in to gauge, but not to tie the hands of the legislature. And for all those reasons, then I would say yes, it's probably legitimate to expect structural interdicts to weigh more against the executive, and it is also legitimate for the court to adopt a posture of being more restrained in seeming to tie the hands of the legislature. I hope I've answered your question.
Yes, I'm okay with that response. And yes, you cannot control what happens in Parliament, and some bills, some parliamentarians can oppose.
Yes.
Lastly, based on Honorable Attorney General's question on if there are certain decisions of the Supreme Court you don't agree with, I just want to read you a phrase here. Respect for precedent must not mean refusal to re-examine wrongly decided cases. If appointed as a Supreme Court judge and having identified some of the gaps in matters that you have listed, would you be in a position to, depending on what comes before you, to re-examine wrongly decided cases as a Supreme Court judge, as a bench?
Yes, yes. If it is wrongly decided, okay. First of all, of course, the starting point is to say that it is a collegiate environment. So it's not a question of walking in and calling up files and changing things. It is a question of the environment. That's one. Number two, I think it is a question of every case has its own facts. So it is very difficult to say as an absolute. But even looking at the conversation we've just had, the question you gave me immediately before this, you could possibly argue that the Supreme Court is being more measured in how it is relating with the legislature in this decision of Okiomutata, saying we need to respect each other's space. And so it is a point to say that every subsequent day is a day of learning, and every subsequent day is a day of a new revelation of how better to do things and how to make corrections. Lastly, Commissioner, is to say that the law is I think the Constitution is very explicit on that the only entity that is not bound by its decision is the Supreme Court, but the others are bound by the Supreme Court's decision. And I think then that gives latitude to the Supreme Court to be able to reevaluate their decisions, the circumstances, the issues, and improve on the laws and the legislature and jurisprudence, actually jurisprudence.
Okay,
yes.
Thank you, my lord, and all the best. Thank you, Chair.
Thank you very much. We now move on to Justice Joki.
Thank you, Chair. Let me just move on a little bit from where Commissioner Ngutia has spoken. So, yes, sometimes Supreme Courts must reevaluate and review, but because, like you said, their decisions bind other courts below, how do you balance the ability to review with the need for certainty in the legal system? That's the first question. Another question coming out of your discussion with Commissioner Ngutia is the issue of collegiality. And I wanted to see if you can just let us know what you think are the key elements of collegiality. And assuming you come into the Supreme Court, if we listen to a matter and you have a very strong opinion about it, in fact, you have a completely different opinion from the majority, what steps do you take either to persuade other judges of the court or to make your opinion known in a manner that is collegial? Let me start with those questions.
Thank you, my lady. On the question of review vis-a-vis the need for certainty, I would think the cure for that is to say that the Supreme Court and the cure for that is just the need for extensive reflection and evaluation of the issue, so that by the time a decision is being made, it is not a decision that probably by the break of the next day, there is concern that we rushed into making a decision that we cannot stand by. So my answer is, in the quest to maintain certainty, the pressure on the Supreme Court is to be very diligent in reflecting on what the issue is and to make a decision that will last and will outlive time and other issues, to be as circumspect as possible, to reflect on all possible implications of other laws, the Kenyan situation, the Constitution, jurisprudence, both national and international, and to come up with something that, in good conscience, the Supreme Court is satisfied will stand the test of time and the test of issues. That would be my answer. On the issue of collegiality, and the question is whether what I would do if I have a strong opinion. how I would integrate it in an environment which warrants the need for collegiality. I would take the view that the issue in every collegiality environment is the need to discuss, make your point, attempt to persuade, and see if you can arrive at an understanding. The point being that there is a possibility that even as you carry a strong point, there's a certain perspective that you haven't looked at, so that there is need partly for you to communicate what your concerns are, and also to be pragmatic enough to listen and evaluate the points made by other people, and probably arrive at a common ground. And so my answer to that is that the need for civility and honest discussion and this discussion, frankly and in depth, that you should also be diligent. You don't carry a strong opinion when you have not quite exhausted the scopes of the issues. If at the complete tail end you are completely unable to agree, but you have taken on board everybody's view, but you still think that your point has legitimacy, I would think it is possible to write your own opinion or your own judgment, but then that should be the very last option after having honestly considered, having articulated your point and having honestly evaluated other people's views.
Thank you very much. If we can just move a little bit to jurisprudence and develop jurisprudence, which it is supposed to, according to the Constitution, in terms of the presidential election, electoral jurisprudence, or electoral jurisprudence generally. Your opinion in terms of any development or any contribution the Supreme Court has made to electoral jurisprudence from 2013 up until now? There have been a number of elections. Has the Supreme Court developed any electoral jurisprudence? What is the extent of that? Or have we done none at all? Have we been consistent? Yes. Have we been, I would like to hear your opinion on that.
Okay. So, I think the consistent position that the Supreme Court has taken, okay, there are issues where there has been change, and I'm particularly referring to the first election of 2017, when there was a different approach. But the 2013 elections, the October 2017 and the 2022, I think you could almost say they have some similarities. And the similarities would be the criteria, first of all, let's say the standard of proof being that it is a standard of proof referred to as intermediate, being neither beyond reasonable doubt nor to the lower scale of balance of probabilities. It's somewhere in between there, except where two issues are being argued. Either allegations are being made of criminal nature when then the standard of proof is higher to the standard of beyond reasonable doubt, or where arguments are being made that the data does not meet the requirements of the Constitution being 50+1. I think the law says then you need to prove that point beyond reasonable doubt. So beyond the reasonable doubt on criminal allegations and on allegations that the faults do not amount to the numbers and criteria required for declaring one elected. The other one is the other one that has been consistent through the period has been that the elections would not be nullified merely because there are some legal infractions, that some aspects of the law are not followed. The court will look more at the principle, whether there is a substantial compliance with the law and the defaults do not affect the results. If the infractions are not so grave, and if on its face they do not affect the results, then the elections are to be upheld. And this is informed by the general proposition that elections being a human activity, there will always be challenges here and there will always be a problem with one legal compliance or the other. And so the issue is more to look at the substantial and to give the wishes of the populace, to give right to the wishes of the populace, that if the court is satisfied that the wishes of the populace has been achieved by the elections, then it is sustained. The third one, I think, from all the elections is that progressively we have, the elections have been technological, using the integrated system, which is used for purposes of registration, identification, and transmission. That even when technology is used, it needs to be auditable. It should be possible to audit them to confirm that they are transparent, accountable, and they reflect the wishes of the people, and they have not been manipulated in the course of it. Now, the outlier case of 2017 August is that in that case, the Supreme Court took an approach that they then subsequently came back to in October and 2022, or rather they abandoned, and they went back to the 2012 position, being this, that in that case, the Supreme Court said that the only thing we are interested in seeing is whether the process was right. And the moment the petitioner has persuaded us that the process was not right, the question of whether or not the votes were properly counted, whether they were properly verified, whether they were properly collected, is irrelevant. We will put our full stop at the point of the process. If the process is faulty, then that is the end of that. And I think in that case, the issue was not so much that the elections were faulty. The issue turned on an order made by the court that the IEBC should give access to the servers and the logs. And IEBC, I think there were issues of saying, we here in Kenya, we are at 1 o'clock. In France, where the servers are hosted, it is midnight. Anyway, basically, there was no access to the servers and the logs. And the court said, we will draw an adverse inference against the IEBC and the respondents, in the sense that their refusal to give us access to the logs and the servers is an indication of the possibility that the integrity of the transmission of those results was not proper, and therefore that process is nullified. I am aware that there was also a very huge argument around it on the question of the conjunctiveness of section, I think, 83, which is the same issue I was saying. Whether there are two standalone requirements in that section 83. One aspect being that you comply with the law 100%, and the second one, that the results have not been affected, that you have to demonstrate the two. In that case, the court said they are disjunctive, you have to prove each of them separately. But then subsequently they said it is one requirement. Even if there is fault, you still need to show that even that default did not affect the results. Lastly, my lady, is that in all the elections, the court has maintained the position they took in 2013, being that rejected votes do not count in determining 50+1. And the court's position was that when it is rejected, and most importantly for purposes of a petition, that vote does not benefit anybody. So you cannot say one person benefited against the other. It's rejected, it doesn't count, it doesn't inform the 50+1. So 50+1 is all the votes excluding the rejected votes. I know I said lastly, but probably allow me to just say this one being the very lastly one, that in 2022, the same question that arose in August 2017 arose. Being in 2022, whether the results could be verified, particularly transmission, and whether there was interference with Form 34, I think 34A and 34B, or 35A and 36, I'm not sure. But basically whether the forms that were on the ground are exactly the same ones that were transmitted and are the same ones that informed the data that was announced by the IBC. And unlike August 2017, in 2022, IBC gave full access to the servers and the logs. And as a result of that process, the reports were filed in court from the petitioners, the respondents, and the registrar. And the court then was satisfied, unlike in 2017, that indeed we are able to verify, and the court was also able to compare the forms, which I'm not sure whether they were 34, 35, or 36.
That I think is sufficient.
Okay.
Let's move from domestic law to international criminal justice, which you say you have experience in, and that therefore you make a contribution to the Supreme Court. The International Criminal Court, which you're familiar with, uses a hybrid system of common law and civil law. So how would we here in the Supreme Court find that beneficial, or how would we be able to export our jurisprudence? How would that be useful? If you can just explain.
So I think, as AG has always said, the world is a global village now because of migration, the technology, and others. And if you read an article, the scenario now world over is that there's a lot of borrowing between civil system and common law system. And as a result, therefore, the original clear lines between the functions of the conduct of proceedings under civil law and the conduct of proceedings under common law have somehow gelled. I could pick one scenario, for instance. So under civil law, a judge is not an arbitrator, is not neutral, is not just a quiet chair waiting for two people to battle it out like in common law. In civil law, a judge is an investigator. It is inquisitive, it is inquisitorial. So that a judge in a civil process can order the calling of a witness, production of a document, and things like that. In adversarial system, in common law, the ideal judge should be one who lets everybody make their case. And even if the judge were to see that at a certain point, a certain case will be disadvantaged because a certain party is not being diligent or is being careless or is frustrating his own case, the judge would probably still have to keep quiet because short of that, then you would be seen to be taking sides. Now, when you come to the functioning of the oxygen rules, I think Section 3 or Rule 3 in the Court of Appeal and Rule 1 in the Civil Procedure Act and Article 159 of the Constitution, when you look at the requirements of those sections, it is such that it requires the judge now to come out of that very neutral position and to say, what is the justice of this issue, both in terms of procedure and substance? And if injustice will obtain as a result of keeping quiet, the judge is entitled to, on his own, or to require the parties to participate in ensuring the court is fully informed on all the facts and the law and to arrive at a decision. And so your question, my lady, was where does common law and civil law meet, and what is the necessity of it in the Supreme Court? I would say that indeed, progressively, the two systems have borrowed from each other. Even when you look at the case of LGBTQ, some of the cases that were quoted in that case are cases that emanate from systems that practice civil law. So indeed, civil law is here and is with us, and it's a reality.
Thank you, Judge. Finally,